Great. Well, welcome again, everybody. We're so thrilled to have all of you join us. Amazing. So our first paper tonight or today, wherever you are, whenever it is Hila Shamir and Guy Mundlak are going to be speaking. I'm going to be available for questions at the end. I'm also keeping time. The paper is called Mapping the Future of Labour Rights Enforcement in Global Value Chains, a Comparative Analysis of Labour Governance Approaches. Bear with us. We're trying something out. So we're really looking forward to hearing from Jaako after a 10-minute presentation from Hila and Guy.
Okay.
So I'm going to start our PowerPoint, right, Guy? And you tell me whenever you want to change.
Yeah. Okay. So I'll try to expedite some of it. Hila was just writing me, we're doing something nice, but I think it actually repeats a whole lot of things that were said in the conference. And I think that that's part of the whole project. If you can move one slide down. And the idea is that in our joint project, the three of us, in our individual projects, and I think throughout the whole conference, we're talking about the importance of enforcement. And clearly the recurring theme in a lot of the literature on global value chain governance is about lack of enforcement. And that's a bit obvious. What we're trying to do is actually ask ourselves, when we're talking about enforcement, what are we actually talking about? And I think we think that oftentimes the image is something similar to some utopian domestic law, where there's a violation of a labor right and an individual can turn to the labor court and sue the employer and then get a remedy. And that's enforcement. And obviously, that's not going to work in the same way when we're talking about global value chains. And the complexity of the thinking about governance also requires to think about several components, which we think that if we're going to miss out on at least even on one of them, we're not going to have full enforcement. And the flip side is that even when we're talking about soft law that is allegedly non-enforceable, we actually do have some components of the enforcement method. So clearly, when we want to start to think about how to put all of this together, then we want to think about drawing in the comparative advantages of different tools in order to see how we can reach a framework of enforcement. So if we move to the second slide, so I'm going to skip all the background and theoretical thing. What we're doing actually is we have 6 building blocks of effective enforcement, and then I will present those, and Hila will present 6 types of governance instruments where we test these kind of components and see what we have and what we don't have. And actually, I jotted down during the conference in different papers, different references to this component or to the other. But due to the time constraint, I'm not going to go into this. But if some of these things sound familiar, then I think it's good because they do connect with a lot of things that have been going on here over the last 2 days and in the literature on governance. So what do we have here? The first component is the idea that we need clear and specific prescription of rights, duties, and obligations. So if we're going to have, while the authoring of norms is supposed to be something different than enforcement, if the norms that we have are just general freedom of association or general let's protect health and safety, that's not very useful. And we want to actually see a list of duties and rights that are specified to the extent possible in order to make enforcement feasible. The second component is the idea of multi-directional information flows. And Hila, if you can go one slide down to the slide that I added this morning. So we're talking about 4 types of information flows, and actually all of them have been mentioned explicitly over the last 2 days. So one of them is downstreaming, and that's how do we take rights and obligations from the instruments and inform workers about their rights. The second is upstreaming, and that's how do we lift up claims of violations and how do we bring the information up the global value chains. Side streaming, side streaming refers to the transparency of what's going on the ground to the social and economic monitors. So even if we think about consumers as monitors or local communities that EC is going to talk about, or financial institutions, can we make sure that information goes to others? A good example would be in better factories in Cambodia, that once they stopped informing third parties about which factories are violating or not, we saw an increase in the violations. So that would be the side streaming. And the fourth is the learning loops. So that's how do we use information that is being collected and monitored over time in order to see what's working and what's not. So if you can go back one slide, Hila, to the general scheme. So the third component is launching grievances or complaints without fear or retaliation. And again, we talked about this, and partially it would be about whistleblowers. But once we move from the norms to the information, we actually want to start thinking about the actual process of launching grievances. We want to have effective grievance systems that require safe reporting channels and strong whistleblower protections. So these can also include models of co-enforcement, where government partners with civil society organizations, and they offer a potential solution by creating safe spaces to the workers so that they can raise their concern. So we move one stage further, and that's a competent and independent authority with the capacity, authority, autonomy, and resources to actually remediate violations. So I think this is quite obvious, but again, emphasizing the need to cooperate with workers' representatives who are not dominated by the employers. So partnerships with external agents can secure the independence and legitimacy of the relevant authorities. The fifth component is the dispute resolution mechanisms must be accessible, affordable, and tailored to the nature of the grievance. And that's to ensure that workers can actually seek redress without being deterred by lengthy, expensive, or overly complex processes. And here we would like to see some kind of differentiation between different types of processes. So we can think about on-the-ground processes. Something went wrong during the day, then we want to have some kind of a way to address it at that particular moment or on that particular day. We want to start thinking about self-help remedies. For example, that workers can withhold their labor collectively in a protected manner. And that points to the importance of the right to strike in this context, and also the right to seize work where there is an imminent safety hazard. And some actually view that to be as an integral part of the right to strike. Now, unlike the shop floor grievances, there are matters that should be handled outside the specific workplace and should be, and then we want to enable to examine compliance practices as a whole and not focus on one particular instance. And for those, we need different kind of institutions. So we want to actually have a system that differentiates between levels of grievances, where they take place, and what would be the appropriate way to address them. And finally, it's the sixth building block, and that's that enforcement must ultimately lead to meaningful redress and enforceability of remedies. So Hila, if you can go down 2 slides now. Okay, so here we're thinking about 3 subcomponents. First of all, the obvious, individual remediation for past wrongs. So some of the methods that Hila will present think about the future or how to correct things, but they're not really addressing the violations towards individual workers. Other systems think about how do we compensate an individual worker who was hurt, but they don't have the component when we need to identify the agents who are responsible for future change, so to ensure that violations will not reoccur. And thirdly, and more generally, I think some forms of remedial action must also include the expressive value in assigning responsibility in complex global value chains. And this is the part where we find a way that remedies will make it clear that the higher nodes in the global value chains are responsible for workers' rights down the value chain. So these are the 6 components, and basically they would create the ideal enforcement system. Probably they do not exist, and they do not exist, I think, in domestic law in any kind of a perfect way. But Hila will show how we play around with it in the 6 different case studies that we chose.
Thank you, Guy. So our study, after doing kind of building this analytical framework, maps different enforcement approaches ranging from voluntary corporate mechanisms to legally binding regulation using these 6 identified building blocks as points of comparison. Now, each model offers different levels of enforceability, worker participation, access to remedies in each one of these 6. While some impose legal obligation, they may lack enforcement, others have enforcement, but allow only, but address only narrow labor rights. So we're kind of trying to map all of this. I won't be able to do all of this justice here. So this is gonna be just kind of a bird's eye view. So start with the first 3 that we're looking at. So CSR, private ordering, as we all know, corporate codes of conduct, industry-led certification schemes rely on voluntary compliance. While they may set detailed labor standards, enforcement is very weak. Grievance mechanisms are often company-controlled, and independent oversight is often lacking. Similarly, when we look to international guidelines like the OECD guidelines and UNGPs, they promote corporate responsibility, but lack the binding enforcement. National contact points, NCPs, provide a forum for complaints, but offer mediation rather than concrete remedies. If we look at transnational litigation, it kind of offers some promise and remedies. It aims to hold corporations accountable in their home countries for supply chain violations. However, jurisdictional barriers, as Guy and Judy show in their article about this, high costs, lengthy legal processes make it largely inaccessible to workers. We have very few cases. Some of them set important legal precedents, but this remains unpredictable, impractical enforcement tool for most labor violations. So to bring these 3 governance approaches together, these approaches shape corporate norms, but lack strong enforcement. In contrast, the following 3 that we look at, mandatory human rights due diligence, worker-driven models, and trade-based enforcement provide more binding mechanisms with sanctions, but have other downsides. So let's move to those. Let's start from the last one from HRDD, such as those in Germany, France, CSDD. We have discussed them. They aim to regulate corporate responsibility by requiring lead firms to identify, mitigate, and prevent labor rights violations in their supply chains. And these laws establish legally binding obligations, even though the sanctions are still not clear in some of them, to ensure that companies integrate labor rights considerations into their business operations. However, enforcement, as we know, is primarily procedural. It's focused on reporting, risk assessment, and compliance monitoring, rather than providing direct remedies to workers. So while HRDD laws make some progress in corporate accountability, they often lack strong worker participation, accessible grievance mechanisms, and meaningful redress for past violations. Now, the most promising model, as we've heard from Jen, Catherine, and Victor on day 1, are worker-driven models. Fair Food Program, Dindigul Agreement are 2 examples that we already discussed in this conference. They take a different approach. These initiatives place workers' rights at the center of enforcement. They use continuous oversight. We heard the 50% of all farms at every season number about the FFP. They have independent monitoring. They have binding economic consequences for non-compliant employers. Unlike HRDD laws, they rely on corporate self-regulation, though. And although worker-driven models ensure that grievances are addressed quickly and effectively by those most affected, these models still remain dependent on voluntary corporate participation, lack the formal legal authority of state-backed regulations, and as we've heard again in the paper on our first day from Jen, Catherine, and Victor, it's difficult to get lead firms engaged in them, and suppliers sometimes. Finally, trade instruments such as USMCA, rapid response mechanisms, and Section 307 of the US Tariff Act that, again, we heard Desiree talk about this on day one. As we heard from her, they operate through economic sanctions to enforce labor rights. And they seem very appealing, and there's a lot of interest in them because they offer this really strong sanction. But this powerful tool of blocking imports from factories that violate labor standards, this tool does create tangible financial incentives for compliance. However, again, as we heard from Desiree on the first day, enforcement tends to be opaque, exclude workers from decision-making, reach only a certain layer of a worker, and focuses primarily on extreme violations like forced labor, violation of freedom of association, rather than broader labor rights protections. So unlike worker-driven models, trade mechanisms lack direct worker involvement, and unlike HRDD laws, they do not place responsibility on lead firms. They often target suppliers instead. So to compare these approaches, we see that HRDD laws impose legal obligations, but often lack strong enforcement. Worker-driven models offer the most responsive enforcement, but lack institutional power resources to rope corporations in. And trade mechanisms provide strict economic consequences, but often exclude worker agency. So we kind of end with a more effective enforcement model that would kind of integrate elements of all of these. I'll skip this for the sake of time. I'll just say quickly that in the paper, we discuss a promising development, which is the proposal for an ILO convention on decent work in global supply chains. This is still very much a dream. The draft we analyze in the text was promoted by the Solidarity Center, seeking to come up with a vision for the labor side of the ILO. And Shelley and Ingrid worked on drafting this really beautiful draft, but it's a blue sky draft, right? By the way, it's available online for those interested. We describe it in the paper. And it really aims to integrate enforceable grievance mechanisms and corporate liability into an international framework. However, as we know, even if it miraculously gets adopted as is, which it will not, as we all know, the effectiveness of such a convention will, of course, depend on its ratification and implementation at the national level, something we've seen as a challenge with past international labor agreements. So even this blue sky instrument, as promising as it is, will have problems. So we end with calling for a hybrid model. And we've heard that here as well already by Dev, who mentioned it on the first day. So we argue that a hybrid enforcement model combining strong state enforcement with worker-driven governance holds the most promise. And again, we heard Dev point in this direction on the first day of the conference. This means integrating binding international norms with the centralized worker-led monitoring and grievance mechanism. By merging the strength of international guidelines, HRDD, trade-based and worker-driven approaches, a hybrid model could create a more robust enforcement framework that might ensure accountability while empowering workers. So just to sum up, effective labor rights enforcement requires more than legal obligations. It requires these robust mechanisms that are transparent, accessible, offer learning opportunities, that are swift and effective dispute resolutions and adjudication, and we argue are worker-centered. So our comparative analysis at this point and at our 3-day journey, again, will not come as a surprise to anyone. We suggest that a combination of international regulation and grassroots enforcement is probably the best path forward. I'll say that in another article, Shelley and I tried to develop this further using the Matadi model, but we'll leave that for another day. Thank you, and I look forward to the discussion.
Thank you so much. That was a lot more than 10 minutes, but it was so profound and so interesting that I just thought that I would let it go.
It's not that you're biased
Exactly.
or anything.
Not at
It's an
all.
objective
that you have any
data.
kind of
Exactly,
involvement in this.
I was just so riveted. I couldn't move you on. Jaako, we're really looking forward to your comments. Thank you.
Thank you. Can you hear me?
Yes, we
Yes.
can.
Always double checking that on Skype. Sorry.
Good
Yeah. Thanks on my part for a wonderful paper, extremely rich in detail. I think you have all the pieces there, and I guess my comments are these irritating ones that I, for one, so occasionally feel are too simple to make. But actually, the first question that I would have is the same that I posed to Anna Beckers yesterday. Why are you talking about global value chains? What additional value does the GVC terminology bring to this? And for me, at least, GVCs mean much more than a lead firm supplier-employee perspective. And especially towards the end, you propose a GVC convention, and I start thinking about what would that be? But then you refer to the ILO convention, decent work in global supply chains. That, well, does it adopt an explicit GVC perspective? I don't know, but I dare say not. So is there any GVC language that is relevant for here? And of course, you can just use the GVC concept for its potential flashiness, but I would expect some kind of a definition and justification for its use, especially as there are tons of other things going on, like the ILO convention on supply chains. Or at some point, you talk about transnational value chains, and which raises the point of what is going on here. So is the GVC concept really useful for your analytic purposes here? Jeremy 2014, of course, provides one classic definition, but then it would be nice to know how you understand this and how you expand on this. And I'm feeling that there's something going on with the power dimensions and the governance typologies that you might be interested in when you talk about, for example, future change and striking at the heart of the global multinational instead of a subsidiary or a supplier. And here, again, you might spell it out and maybe cite, I don't know, Dallas Ponte and Sturgeon's powering global value chains, just to sort of get it off the table. Why are you talking about GVCs and not using ILO's terminology? And now I have to say that I didn't perhaps read this in all detail, but I didn't it didn't overtly, explicitly come to me why GVCs. And I have no idea, well, very little idea about the ILO convention, but I would imagine that does it talk about GVCs? Maybe in some guidance, like the EU instruments that never talk about GVCs directly, but refer to them in guidances. I don't know. So that's my first question. Second question, and this is probably even sillier. Why are you talking about labor? And I sort of understand why you're talking about labor. You're labor lawyers. But if you're talking about, and this focus on the ILO conventions, but imagine a reader who doesn't know what you're talking about the enforcement of transnational claims, focusing on the enforcement. What's so special about labor vis-a-vis, for example, environmental rights, human rights, business claims in transnational situations? So again, somewhere there, I would want some kind of, I don't know, maybe it's not necessary if this is only going to a purely labor forum, but there's so much debate going on transnational enforcement in all these other contexts. So some kind of a connection to them, or maybe some kind of a pointer to these debates. Tax, environment, business, human rights. They all have basically the same questions, and I would wonder if the labor focus changes anything from these, or whether it's basically the same. I'm guessing there are some changes, but then again, maybe not that many. And then I start thinking about when you talk about labor, and I think Guy, you already mentioned this, but you mentioned Guy was talking about local standards of labor claim enforcement, and I think there's again much more there that you could draw on, and especially if you take some kind of a brief historical overview about how these things developed in national contexts starting from the 1800s. I don't think you need much there, but I kind of, now that I listened to your presentation, you talk about legal pluralism, and the labor situation is very fragmented in many different countries within these situations. And you could say that there's a legal pluralistic approach within individual nation states regarding these kinds of claims. So that might also be something to at least mention or adhere to. There are so many different things, and there were so many different things in the paper, but I still started wondering, if you talk about labor, there's well, insurance schemes, for example. Could one imagine their transnationalization or compensation funds or something like this? There's so much detail in national labor schemes, so much pluralism. So this might then serve to highlight also some of the gaps or problems in the transnational thing, if you would do some kind of a brief overview of this, I don't know, national development. All these topics, all these questions are some things that I would love to talk about for ages, but I guess I have to be somehow brief. Yeah, and this is also irritates me a bit. Enforcement. Are you really talking about enforcement or remediation? Instinctively, I would classify, for example, apologies, whistleblowing, affordability as falling under remediation, whereas the enforcement from a classical legal perspective then would entail, for example, a claim for damages or an injunction without much focus on peripheral matters such as content and cause. But of course, these are fluid definitions, but I think a reader would start thinking, enforcement is the big thing that we're talking about here, is the focus. What's the difference then between enforcement and remediation from a classical or from the perspective that you adopt? So just to sort of hedge your bets there again. These sort of questions, these sort of initial conceptual clarificatory questions lead me then to methodological issues, I suppose. And again, correct me if I didn't read this profoundly enough. But yeah, so for example, the 6 building blocks, clear and specific prescription of rights, duties, and obligations, feedback loops, lack of... There's a lot there that could be added in footnotes, for example. Oh, one of the things that I have to apologize for is that I didn't ask for a version where I could actually see your sources, so I haven't checked what you're referring to. That was... So I might have missed something there. But for example, if you talk about feedback loops, then I start thinking about stakeholder interaction. And as Guy noticed, there are many ways of framing these things, but then that might be good to have somewhere there your own frames, how this then would then relate, for example, to stakeholder interactivity or something like this, these feedback loops. But the whole point with the 6 building blocks is that I somehow felt that I did not know where you drew them from. And that would then be the methodological point. How did you come up with these 6 building blocks? And I can think of several approaches that are similar. I feel the building blocks themselves support their validity by themselves. But for example, last year I was the examiner of a doctoral dissertation entitled Continuously Developing Human Rights Due Diligence, Operationalizing Access to Remedy Impediments and Opportunities. That didn't talk about enforcement in the title, at least, but it was an article-based dissertation that focused then on proactive contract theory from a stakeholder interactivity perspective, whistleblowing mechanisms, collective and collaborative worker-driven mechanisms, corporate responsibility, ombudsman, these kinds of things. Even there, I wondered, why focus on these things? How do you make this frame? How have you chosen these 6 things? Well, like I said, I see similar things in different places. At some point, when I was reading this, I even started thinking about functional contracting theory, which sort of somehow aligns with several of these, maybe not all the building blocks, but many of the building blocks. So there's something going on, and if you have a chance, maybe some more comparative material or methodological explanation of where you derive these and how they relate to other than approaches to talking about enforcement, I guess. And that, well, I already said that, but the clear line between enforcement and remediation would be something that I really would hope to see. 5th question I have is the typology of the case studies. Again, I mean, it's sort of intuitive private ordering systems, international instruments based on goodwill, hard legal measures. Then you have 3 things under there: state-based regulation, transnational litigation, interstate arrangements. And then finally, grassroots power. And at some point I wondered, you seem to be talking about the Bangladesh Accord as falling under grassroots power instead of, for example, private ordering systems or some kind of a semi-hard system. I think at some point you talked about contracts as being hard law instead of soft law. So there's some conceptual clarity that could be useful here. But I guess, again, this is a draft paper, so that's what we will be focusing on next. I think I spotted a mistake at some point. You were referring to the Bangladesh Accord as using the ancestral arbitration rules as its dispute resolution mechanism. And this stands true, I suppose, for the 2018 version of the Accord. But I think you were at the same point of space, I think it was page 31, referring to litigations taking place under the old Accord, which was actually utilizing the ancestral model law on arbitration, which is one of the most curious choices I've ever seen in my life. Why choose the model law in a private contract instead of what you usually choose in a private contract, the arbitration rules? So you might want to double check that I think if you're talking about the earlier accord, then it's the ancestral model law. I would love to have a lecture at this point about the ancestral arbitration model law, but I won't go into that. There was something about the intertwined complementarity of these case studies that, again, I mean, there was this weird dissertation that I was examiner for, which talked about a remediation cycle and tried to then, I think, organize all these different private ordering systems and different whistleblowing mechanism into this intertwined complementarity approach. And that's sort of, again, how I feel I understand your regulatory pluralism or hybrid pathway. But there was something, well, for example, one of the things that I started thinking about during your presentation was when you referred to the state-based regulations, I felt that you were making potentially broad generalizations on the contents of these. I mean, in the table, and I mean, you just have to see whether you can stand with that. You might argue in different ways about that. But then I wasn't quite sure if with the hybrid approach or the regulatory pluralism or the other, well, the alternative to the centralized international convention, you meant binding all these together in this kind of a remediation cycle where everything else works to create this system, or whether there was something more there. And I sort of felt that you didn't feel that that was a positive, potentially positive development. And I was wondering, maybe you could have elaborated on that, but maybe it was just that you focused so much first on the centralized, the ILO convention thing, that drew much effort, and that was sort of utopia, and then you had the reality. And I think many parts of the reality are also very utopistic. For example, I don't know where the Article 29 of the CES-DDD now stands, but the whole point of Article 29 CES-DDD was to create this, not really, well, maybe an enforcement framework, but more like a procedural framework that creates these cost allowances, burden of proof benefits. This procedural medals with these tiny nitty-gritty procedural parameters that are crucial then for the enforceability of claims in practice. But I don't know how much time I had here. I think those were my most points, but I'd love to just keep on going. I really enjoyed this. I thought it was a great paper. It raised very many thoughts, and well, it's irritating to be here and you're there and we can't really lug around about it. But thank you.
Thank you so much.
Thank you.
Thank you. They're really useful comments. Oh, yeah.
No,
What is it?
I forgot to say, the GVC thing sort of applies to all the papers I've read to date, not just you, and something that maybe should be addressed at some point. What are these GVCs and how do people, I mean,
I think that's a good topic. That's a good topic for Onyati for a roundtable.
Yeah, it is a good one. So we only have 4 minutes left of this session. Guy, I wonder if you wanted to say
I would
anything
prefer
about...
if other people have comments that we can take home, and because you know, we're at a preliminary stage. So if there are other useful comments, I think that would be way better than if we talk about this.
It's a good use of our time rather than answering. Yeah. So any others? We have...
So we have
Roy,
Klaas,
Yaniv,
and I see Shay as well.
And Shay. Shay, I'm going to take you first since you're probably going to drop off soon with exhaustion.
Yeah, it's actually true. It probably just sounds really obvious, and after Jaako's really precise comments, feels very global. But it's interesting when I was listening, and to some extent, kind of the whole project kind of feels like what we're doing is regulating around the failure of freedom of association, the failure of unions, because we build. I was reflecting as you're talking about the 6 enforcement tools there, and I was thinking, in a traditional AR model, these would be carried out by trade unions, and yet what we've got, just the comment that I wrote down is we've got this failure of collectivity. We've got, in laws that are empowering employers to act transnationally while disempowering workers at the same time, leading to this outcome. And I just kind of feel like it's almost underpinning everything we do. So for me, when I was listening to Guy and Hila, that the refrain in my head was, where are the workers in this? And they're in there a little bit, you know, when Guy talked about the importance of the right to strike, right within that, but they're kind of a missing piece of the puzzle. Anyhow, that was just an observation.
Thank you.
And I'm going to bed.
Plus.
Good night, everyone.
Okay,
Good night,
sweet dreams.
Shelley. Thanks for attending.
Yeah. Plus.
Sure. Thanks. So two quick points. The first one, to echo Jaako, I think there's indeed something with this term of enforcement that at least me makes me think of, you know, the theory of norms around it, where enforcement always comes from the idea that we can separate the formation, the interpretation, and then the enforcement of norms. And these three steps are, I think, less and less separable in many of the instruments that you're looking into. And enforcement always suggests that it's a distinct step that some instruments are able to make, whilst others perhaps less. And so it seems to block a little bit this basically iterative, connected nature that, you know, characterizes most of the tools. And the second point, and this is not supposed to sound kind of cynical, but I feel it's a paper and it's a taxonomy that is still very much written with a positive twist to it, or a positive outlook, in the sense that we're identifying weaknesses of each of these instruments in the hope of making them better. And I think that's how the field has narrated itself for quite a while, but perhaps we're at a point where one additional dimension actually needs to be added to the analysis, namely kind of resilience and vulnerability to backlash. So how easily can some of these instruments be rolled back? How sticky are they? What political forces are they vulnerable to? Or put differently, also, how quickly can they be brought into the picture again? So this whole question of, basically, how can we lock in the initiatives that have been developed already? And connected to this, we have a lot of work that tries to develop these types of taxonomies. And there's always the risk that ultimately we lead to playing them out against one another, the individual tools, whereas I think what we see in practice is a lot about kind of intersections between different instruments, and I wonder how that could be reflected in your taxonomy as well. Thank you.
Thank you. I think we only have time for one more comment. And Yaniv, your hand was up early. So I'll take yours. And but we don't want to lose.
If we only have one more, I will let other people say it, and I can email Hila and
well, if you could put it in the chat, that would be amazing.
Or email, all of it.
Or we'll take you for coffee on campus.
Yeah,
okay, but someone
absolutely.
else can say their
Anna,
point.
you had your hand up, and Roy, maybe if you
I can make it very
yours
quick,
as well.
just to, I mean, now the GVC terminology that Jaako put, I think in your case is quite, to me, one of the questions I had, are you really talking about GVCs, or are you talking about corporate liability or corporate enforcement accountability? No? Is this still sort of in the GVC frame, or are you more in the labor law frame with like employee-employer, no, and corporation-employer frame? So that was like a short question comment that I think this might be needed to be clarified.
Great. That's really helpful. Thank you to all of you for your comments, and apologies for the terrible timekeeping.